The next case is Frederick, Judice versus FedEx Ground Package System Inc. et al. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I will be keeping track of time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument if that applies. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Thank you, Your Honors. My name is Suzanne Stocker, and I'm here on behalf of Mr. Judice. I would like to reserve 2 minutes of rebuttal time. We believe that there are material facts which the jury could look at and find that the plaintiff's injury was sustained in the course of and arising out of his employment with FedEx, thereby precluding a finding of summary judgment. In the course of relates to the time, place, and circumstances surrounding the accident. Plaintiff was punched into work at the time and was on company property at the time of the injury. Definitely, there's no question he meets in the course of his employment. And again, that was not argued at the trial court level. Arising out of refers to the causal relationship between the employment and the accident. And you have to look at 3 things: the proximity of the scene of the accident to the place of employment, the degree of control the employer exercised over the scene, and the benefit the employer enjoyed as a result of the injured employee's presence at the time. As I indicated, plaintiff was at his place of employment. At the time, he was in the warehouse for a pre-shift meeting, which was usually held before they went to their respective locations then within FedEx. I believe what we're looking at is at the degree of control the employer had over the scene of the accident, as well as whether there was a benefit to the employer. Plaintiff worked on the dock at FedEx, where he moved heavy packages. Therefore, he chose to wear composite toe boots to protect his feet. According to FedEx policy, which was given as an exhibit, employees could wear work boots or shoes as long as the shoes had non-skid soles. According to the plaintiff's affidavit, he was required to walk through the metal detector in the security building before he went to the warehouse. He had to remove his boots since they caused the metal detector to go off. All employees went through the metal detector, took things out of their pockets, put them through a little window, took off their boots or shoes if they caused the metal detector to go out, put them through a little window, then proceeded through the metal detector, through a little turnstile where they picked up their items. When he picked up his items, he did not tie his laces, as he usually did, and he had been employed there about 3 to 4 weeks. He would walk out of the security building and into the warehouse where that pre-meeting was held. Usually he'd look for a table in the warehouse where he'd sit down and tie his shoes. It has to be noted that defendants stated in their brief that plaintiff just elected to remove his boots. That isn't quite what happened. He was required to do so. Nobody's gonna, in a company of FedEx size, is gonna let somebody go through beeping a metal detector. So first, there's no evidence to the effect, to that effect, and second, just kind of doesn't make sense. The defendant's own work environment guidelines stated that employees wearing steel-toed boots or shoes may be subject to additional searches, which in this case he was. Therefore, he removed his boots, like I said. When he gets to the warehouse, he looks. There's no place for him to sit, so he attempts to stand up, lift his foot, tie his laces, and in the process he falls, sustaining a right to be a fracture. The defendant states that the plaintiff violated company policy when he walked to the warehouse with his shoes untied. Again, their policy was provided to you, and it's actually in direct contradiction to the FedEx work environment guidelines. Those guidelines state that while on the dock, not in the warehouse, the shoelaces must be tied. There was no violation, and nobody ever told the plaintiff he couldn't walk to the warehouse with his shoelaces untied.
Does it even matter if his shoes were untied or not? I mean, isn't workers' compensation about getting injured at work and?
Yes, negligence is not a factor
Negligence is-
on the part of the employer or the employee.
And do we have any ninth district cases even similar to this?
No.
Do we
No.
have any cases?
I mean,
that
there's a
involve
number of cases,
metal detectors, that's what I can.
yeah, but not right on point, I think, with the facts of this case. And as we all know, workers' comp is very fact-specific. So it really has to be looked at each individual case and the facts of those cases. I believe that, obviously, the employer had control over the situation. If he didn't have to take off his boots, he wouldn't have had to put them back on.
Well, isn't going through a metal detector quite a bit of control?
I believe so. And I also think the benefit to the employer in that respect, Your Honor, is that, obviously, again, this is a big facility. They have a lot of different kind of workers. Sometimes the workers are, come and go. So you go through the security detector and you wave your badge because they want to make sure no harmful objects are getting into the facility or guns or weapons of any kind. They try and stop it at that point. So I do think it's creating a safe work environment, for the employees and as well as corporate. And therefore, I think there is, that's the degree of control the employer had over the situation, and also the benefit. In terms of, the defendant cites the number of cases as well as I do in my brief, but I just think they're very distinguishable from the fact pattern in this case. In LaFawn, the employee was climbing into a company bus with shoelaces untied. There's no reason given for why his shoelaces were untied, that he just had his shoes untied. In Anderson, the work boots the employer was required to wear caused a blister because the work boot was defective. Again, very different from this situation. And in Underwood, kind of same as in LaFawn, the employee untied his shoelaces in his place of employment for no reason other than he didn't want to tie them, and he sustained an injury. So I think those cases are very different. There's a difference, and we need to, again, remember, it's not a question of fault. It's not a question of negligence. We have to look to see where the employer was at the time. Was he clocked in? Was he on the company, premises? And is there some type of causal connection between what he was required to do and then the injury? And I do cite Monjoy, industrial conviction versus Monjoy. And yes, it's an old case, but it's still good law, where the employee was required to wear heavy work boots, and a blister, developed on his toe as he was walking over rough ground at a construction site during the day. And the court noted that the employee was entitled to at least a determination of whether or not it was in the course and scope of his employment, because they didn't know whether it was the work boots that caused the problem or walking over the rough terrain during his job during the day that caused the problem. Ultimately, it blistered, he had an infection, and he passed. So in light of these facts, also I think there was an indication from the defendant that the employee tripped. That doesn't show up anywhere in the evidence. And maybe they were thinking of the case of Underwood, but that was not alleged in this case anyway. So just wanted to clarify that. So in light of these facts, I think there are material facts in this case where a jury could conclude the injury was sustained in the course of and arising out of his employment. And obviously, we would ask that the trial court's order granting summary judgment be reversed and the case remanded. Thank you very much.
Good morning, Your Honors, and may it please the court. My name is Brianna Perslipsky, and I'm here on behalf of the defendant in this case, FedEx. Below, the trial court properly granted summary judgment in FedEx's favor upon a determination that the plaintiff's injuries did not have a causal connection to his employment and did not arise out of his employment. And I think there's three main factors that the court looked at that really drove that analysis. One, as counsel just mentioned, there is no requirement that he wear these composite toe boots. The only requirement was that they have a non-skid sole. So these were boots that were specifically selected by plaintiff. One, immediately after exiting the metal detector, there was proper seating there. So he had every opportunity provided by my client to sit, to tie his shoes so that he could walk into the warehouse and not risk further injury to himself.
Was there any instruction in the evidence about the employer making that seating specifically for you to tie your shoes or to sit down after you get the metal detector, or were there just chairs there?
Well, there were chairs there, and I think it's fair to say that, if you walk out of a metal detector and there's chairs there and your shoes are untied, you have the opportunity to tie your shoes and you incur further risk if you continue further.
But probably multiple people are going through the metal detector too, because every employee has to go through, right? Is that part of the evidence or no?
That other employees go through the metal detector?
Right, that there's a line and people are trying to get through.
Well, the chairs were not, I believe that the chairs were not occupied at the time. It was only after entering the warehouse that that the plaintiff had intended to sit down and there was unavailable seating.
And he's not actually clocked in until after he passes into the warehouse, right? So the chairs were before he clocked in, right?
I believe so. But, correct, so he had the opportunity before entering the warehouse, and, the warehouse is on his way to the dock where he works. And, at that point, he had the opportunity to sit. He elected to go forward. When he entered the warehouse, he found that, the chairs were occupied. Instead of, asking briefly to sit down, instead of kneeling, he attempted to tie his shoes from an unsafe standing position, at which point he trips. And I note that counsel, says that there's no evidence that he tripped, but there was no, there was nothing, there were no hazards, I'll say, in the area. The floor was clear. There's an allegation that maybe it was a polyurethane floor. There's no evidence of that.
Well, could it be argued that as soon as you go through a metal detector as a requirement, that's for the benefit of the employer? He wouldn't otherwise have to go through a metal detector if he wasn't going to work. So, and then if we're talking about no fault, does it really matter what happens upon entering the metal detector, as long as the employee is injured? We're talking about workman's comp, not a tort.
Sure, and I understand, but one of the elements here, there's a control aspect and a benefit aspect. And what was within my employee's control is it provided seating that he didn't use. They can't, necessarily force him to sit down and tie his shoes in a safe manner, but, he had opportunities to do so in a safe way and didn't utilize them. And that's, why we cite several of those cases that counsel mentioned, Anderson, Underwood. To the extent that an employee is going to attempt something in an unsafe way or, not be safe in a way that's within their control rather than the employer's, that causal connection there is broken. And specifically, I think LaFawn's a very helpful case because in that case, they affirmed summary judgment despite finding that, the fact that he was taking the shuttle did provide a benefit to the employer.
Are any of the cases you cited ninth district cases?
I don't believe they are. I don't think there's a ninth district case that's well on point here. I believe LaFawn might be a second district case, but the analysis is still instructive.
Are there any cases that involve metal detectors that you could find?
Not that I could find. Part of that is, as I see it, the causal relationship here isn't necessarily the metal detector, but the fact that his shoes were untied and he elected to tie them in a way that was unsafe despite having opportunities to do so in a safe way.
Counsel, let me ask you, if he was going through the metal detector, what would FedEx's position be if he tripped right before he was getting in, taking off his shoes?
Well, I think it would depend. I don't believe from the record that there was seating beforehand, but I think it would come down to how he did it. If he's doing it on one foot and is unstable, I think we could make the argument still that that's not in our control, that he, if he wasn't balancing himself, if he knew that he couldn't stand properly. But the fact is, in this case, we're far removed. He had the opportunity to sit down and tie his shoes and proceeded further.
But the point is, workers' compensation cases are very factual.
Correct.
And they're very factually intent, and it's supposed to be interpreted liberally for the worker. But this was a summary judgment motion.
Yeah, and, the cases that we cite, Anderson, Underwood, LaFawn, those are cases that were also decided under motions for summary judgment. It's really looking at, is there an issue of material fact? We see that, he exits the metal detector, has the opportunity to sit, doesn't utilize that, proceeds on. If we're looking under, the elements that we're supposed to in determining whether this arises out of employment, the aspect of, control by my client, the benefit, certainly he does, my client does receive a benefit from him proceeding through the metal detector, but, there's steps in between him exiting the metal detector and him falling that, are breaking up that causal chain. He, again, and not to, really belabor the point, but, there was a safe means that he could have tied his shoes. I think it would have been, similar if he had just tripped over his own shoelaces. If he had the opportunity, which was
So what
supplied.
if he just tripped over his bare feet getting to the chair that the employer provided?
Then, I think, we could talk about whether or not he had a fair opportunity, but in this case he did. He had an opportunity to sit before proceeding, and he just simply didn't take it. And then once he was in the warehouse, rather than, again, kneeling to tie his shoes, which is a much safer means and invites less risk, he attempted to do it while standing, and, he lost his balance. And, it's these elements that the trial court was looking at when it granted our motion for summary judgment, specifically because when we're looking at the cause of the fall, the cause is that he elected to tie his shoes in an unsafe manner after having, other safer means. He was looking for a place to sit, he passed one up. If he had stopped there, we wouldn't be here. And so that, to me, that's what's breaking this causal connection that would have otherwise, that he could have otherwise
It's
relied
very
upon.
difficult with these workers' comp because it seems like that is an argument that's made. I was just on a recent one again where something similar happened. And it seems like the employer is really arguing straight negligence, that the straight negligence in and of itself breaks up the causal connection. Is there any case law that says negligence breaks up the causal connection?
Not that I'm aware of, but I don't think it's negligence by itself, but certainly I think it's a factor that the court can consider, what actions the employee took. Certainly, if an employee is doing something that's putting themselves in danger beyond the ability of the employer's control, that's breaking the control aspect of the causal analysis. So I think there's an intertwinement there. And so, to that extent, because the trial court, had a very detailed analysis, weighed these factors and found that, as there were no issues of material fact, I'd respectfully ask that this court affirm the trial court's decision if there are no further questions. Thank you.
You'll have a full 5 minutes for rebuttal.
Actually, be brief, thank you. I disagree with the breaking the causal relationship. To break the chain of causation in workers' comp cases is a heck of a lot more than passing up a chair to possibly sit on. That doesn't break the chain of causal relationship. In terms of the work boots, yes, he chose the work boots, and yes, he chose composite toe work boots because he worked on a dock, lived in heavy packages, and he's trying to be safe and protect his feet. Any type of work boot that has grommets on it, doesn't have to be a steel toe boot. Any boot that has grommets on it is going to set off a metal detector. And whether it's composite, steel toe, that's just the nature of boots. In terms of the seating, there's a little question here because my client had indicated that he did not see any seating in the area. In fact, on deposition, on page 72, when he is asked, and so what you're telling me is because on July 22nd, 2023, you believe that there was no place for you to sit to tie your shoes. You in fact entered the warehouse with your boots untied. And my client answers yes. And he says, okay. Even in the Exhibit B in my brief, the hearing before the staff hearing officer also notes that he went past the metal detector. There were no benches or chairs there that he could sit on. And truly, I can't recall from the video whether the chairs were before the metal detector and he'd have to loop back around or if they were after. But in any event, I don't even think that is a factor in this case. Just like at the administrative level, the DHO said, no, I don't see a causal connection. The staff hearing officer said, yes, there's a causal connection. He had to take those boots off to get through the metal detector. He had to put them back on, and in doing so, he sustained an injury. So in that light, I think there are issues of material fact where a jury could look at this and say, he sustained that injury in the course and scope of his employment. So I would ask again that the summary judgment be reversed and the case remanded back. And I thank you very much for your time.
The court will take these matters under advisement, issue a ruling in due course. The clerk of court will mail a copy of the decision to you on the day it's released. Also, the opinions are posted on the Ohio Supreme Court website. Thank you both for your presentations.